Face to Face today is going to focus a lot on legal education. You want to know the law so that when people are talking about it, at least you have an idea what is being said and you would have learnt it here on Face to Face. And this is because there was a public spat in the courtroom last week that has generated a lot of controversy. A statement that was made by a person standing trial in court has led to legal controversy with demands for the resignation or dismissal of the foremost member of the Ghana Bar, the Attorney General, Godfrey Adame. On Face to Face today, we'll be looking at the key issues that are coming out from there and also learn some law. My guest is very helpful in that because he has been doing legal education for decades. My name is Umar Rusanda Amadou, and you're welcome to Face to Face. My guest on Face to Face became a lawyer in 1981, many years before I was born. He has been director of the Ghana School of Law. He has done football work for the Ghana Football Association in the past, helped with the creation of laws. Now, he's also founded a law faculty, and he's currently running the Montclair University College in Accra. The church name that was given to him, he rarely uses. It's Samuel, but you would know him more as Kwaku Ansa-Asare. You're welcome to Face to Face. How are you doing?
Fine.
How is life treating you?
So far,
more than 40 years at the bar.
Sure.
Are you not tired?
No.
Because there are people who say lawyers aspire, not every lawyer, but many lawyers aspire to go to the bench. You've done 40 years at the bar. Why are you there? Why don't you go to the bench? And maybe relax yourself, maybe...
But the law has got branches. There are the practitioners, there are the benchers, there are the solicitors, general counsel, those who decide to go into farming, like one of our lawyers, Apia, used to engage himself in rice farming in the north.
Okay.
Lucutera, another, who went into business. So it depends on the individuals, what the individual wants to do, with his life.
But when you gather wealth of knowledge, people want you to take you to the bench and help make law, because the bench makes laws, even though people think it's just a legislature. If with all the experience you have, 40 years being a lawyer, you would make a good judge. Have you ever thought of going there, or because these are things that have to be appointed, you're just there, if you're appointed, fine?
Well, the law is developed by members of the profession, but basically judges and legal practitioners. So because through the industry of legal practitioners, the bench is strengthened, and therefore, what legal sources will bring to their attention is what they use. That's the judges who are not adept to their vocation, and want to rely on the authority that lawyers will cite. Then there are the judges who do their own homework, regardless of whatever contribution
the lawyers
may make. So you have that type. That is why judges are often categorized into the bold ones and the timorous souls. The bold ones go for the gold. The timorous ones recoil.
Watch the gallery.
Yes. Sure.
But you've never aspired to be a judge?
I would have gotten elevated to the High Court. In fact, Rollins invited me in August 1991. I accepted, but subsequently I had to change my mind, because of my mentor, Mr. Darocha, who thought, that I could make a much more significant contribution to the development of the law as a practicing lawyer and legal educator rather than on the bench.
Okay.
So I changed my mind, on the day that I was to submit my application, to J.J. Rollins through the late, we used to call her Big Madam, Mrs. Anijiage.
Okay.
She found me to be legal material worth going onto the bench. But because I changed my mind, then Kufuor in 2001. So if I had been interested, I would have been elevated to the Supreme Court. But
you said no again.
All my life, I have cultivated certain habits which I find very difficult to change. Very simple person, very humble person. I always wish to mix well, with society. Not regardless of whether you are a farmer or a driver or a lawyer or fish seller. I mean, if I'm a judge, I can't.
You'll be too restricted.
No. I want to eat in the open as a judge. I can't. I want to sell law books, to my law students, which I can't. And then.
Do you like going to the club?
No.
Oh, okay. I would have said that you can't do that one either.
No.
Okay.
That one.
So the restrictions were too many for you. You felt you would be caged.
Sometimes you want to go out, to eat banku or gari and this thing. And then people will come there. You want to judge, crowd gari, that sort of thing. So the limitations,
Okay.
They don't encourage one. Like if you go to America or the UK, the judges, they are as simple as any ordinary person.
They are free.
By years, societal values have said that there are certain things judges cannot do. And if a judge should do that,
but these views notwithstanding, do you regret not accepting Rawlings' offer?
No, not at all.
You don't regret. So you're happy where you are.
No, very, very happy.
Let's talk about the Supreme Court, which you would have gone to if you had accepted Kufuor's option. The Constitution 128 says that it should have a Chief Justice and not less than 9 justices.
Sure.
That is the lowest or the minimum number of persons you can have at the Supreme Court. However, the Constitution does not give us a cap on how many, what the number of judges must be. It should not be beyond. Now, there's a view that this provision is being abused and that presidents over the years have been packing the bench for political reasons. What is your view of this?
I agree with the school of thought. That is the view that the capping of the Supreme Court is to achieve or score political goals. Winner takes it all. But I'm also of the view that the appointee can respect the Constitution and not make any intrusions, not seek to interpret, because the interpretation of the law is the exclusive preserve of the judiciary, not the executive. We have had presidents since Ghana attained independence on 6 March 1957. Under Nkrumah, and before Nkrumah, there were only 2 justices.
Only 2
justices
for the whole Supreme Court.
For the Gold Coast Supreme Court, and the Chief Justice was then in Nigeria. So these 2 the justices of the Gold Coast Supreme Court, and the Gold Coast Supreme Court, its equivalent today is the High Court. Now, whenever there was a tie, the president, the one who presided, will have another vote.
Casting votes.
Yes, so it's a casting vote. That's it. So 2. So if they split, then the president
can come
or
in.
sometimes the Chief Justice will come all the way from Nigeria. So the Chief Justice was in Nigeria, the Deputy Chief Justice in the Gold Coast. The reason why for some time the Chief Justice was in Nigeria is simply historical. Until 1863, Ghana, that is the Gold Coast. There was no Gold Coast colony yet, but there was the British settlements on the Gulf of the Guinea coast.
So we have Sierra Leone, Nigeria, Ghana.
Sierra Leone, Nigeria, Gambia.
Yeah, the
Gambia was then known as Bathurst.
Yeah.
And then the
That's
Gold
the
Coast.
former capital.
Sure. Now, on 24th July 1874, the Gold Coast colony was created, and it consisted of present-day Central, Western, and parts of Eastern region, and then Keta.
So just the south.
Plus Lagos. Lagos.
Okay.
Constituting the Gold Coast. So for 10 years, Lagos used to be part of the Gold Coast colony, and therefore having the spread or the political entity then known as the Gold Coast colony, it became prudent for the Chief Justice to reside in Nigeria, and number 12 Tinubu Square, Victoria Island, Nigeria, and then the Deputy Chief Justice here in the Gold Coast. And the capital there was in Cape Coast. So when in 1877 it was decided to bring the capital to relocate from Cape Coast to Accra, they spent 6 months in Winnipeg to get Accra ready. And Accra in this context is Jamestown, because Jamestown was known as British Accra. The Osu was Dutch Accra. So when we say the Gold Coast colony and we refer to Accra, we mean English, Manfro, and Jamestown.
I see.
You see.
Okay. So that's a very wonderful history. So your view is that because we had less justices at the time, it hindered or it affected the flow of justice. So we should not have a cap, even though the Constitution would say at least 10. Do you have an utmost number in your head?
No, so I was, coming to that. So Kwame Nkrumah did not interfere with the establishment, but it was a gradual process until Kwame Nkrumah established the Judicial Service Commission. The Judicial Service Commission in 1960. It was the Governor General who used to appoint. When the Judicial Service Commission was set up, the number increased to 4. Before Nkrumah was overthrown, the justices were 5. Now, after the overthrow of Nkrumah, the National Liberation Council, came. They consisted of, soldiers and police officers. Did not interfere with it. After the National Liberation Council came Buzia from 22nd August 1969 to 13 January 1972. There was no interference. Then the National Redemption Council came from 13 January 1972 until June 4th, 1979. And all that time. So by the time we arrived for constitutional dispensation in 1992, there had been a history. You see, and each successive government, post-independence Ghana government, respected the number. And perhaps we've been influenced by the American practice. Under the American Constitution, they have not had more than 9 justices of the Supreme Court. Take America, there are 9. America,
including the Chief Justice.
Including the Chief Justice, and these 9 justices have worked tirelessly from 1776 to date. We are a very small country. The size of Ghana is like the size of Oregon in America.
The state of
just
Oregon.
A tiny bit. That's the farthest that we can go. And we are thinking always of having justices, and the worst culprit is the sitting president, who is himself a lawyer, who should know that it is not the quantity that matters, but the quality. We can have 100 justices to come and do what? You can have 9 justices, and if they want to work,
they will.
They will. So for me, in strict observance with the constitutional provision and the mandate, I should think that Article 128, Clause 1, that says that the Supreme Court shall consist of the Chief Justice and not less than 9 justices. We should just leave it there. You know, previous governments, previous presidents have come and worked with it.
So stick to it, even though it does not say you cannot go beyond. But you are saying that the number that has been mentioned.
It's part of the governance.
Let's work with that. What about the other view that the administration of justice is a laborious one? If you have 9 justices, you want to dispense with justice as frequently as you can. If you have 17 or 15 or 21, then at least you always have a standby bench there to assist when this bench is on recess. What do you think?
Oh, America, I've just drawn attention to the American legal terrain. 9 justices, and if dispensation of justice does not depend on the number of justices on the Supreme Court. It all depends on strict observance.
What about the political side of things? So you've said that, of course, a judge is appointed, they have to be true to the Constitution and all of that. But people are still suspicious that they are biased. So, for instance, this current administration, Nana Kwaku, the president, appointing Supreme Court justices. Can these Supreme Court justices be truly trusted to be fair and just to all parties involved? And I know that in the past they were appointed by other presidents, but what do you think of the appointment? Should Supreme Court justices be elected, or the appointment process is all right, but it should be limited in some way?
No, the appointment process, is all right. In America, some justices are elected. I've been to America. I spent 6 months, observing the American judicial and legal system. And I joined some of the justices on their campaigns and this. I don't think, we have the resources, to embark upon that journey. We should stick to what we have. The point I'm making is, Kwame Nkrumah appointed the first Ghanaian black Chief Justice, Sir Akukosa, after independence. And Sir Akukosa stuck to the Constitution. He looked Kwame Nkrumah in the face and told him he was unable to go along with what His Excellency Osagyefo, wanted him to do. And he said, I'll sack you. He said, sack me, if that is the price I have to pay for my loyalty and commitment to the Constitution. That is the kind of Chief Justice
that we need.
Yes.
What about the mistrust, the growing mistrust in our current Supreme Court? If you follow social media, I'm not sure you do, but members of the NDC are calling the Supreme Court the unanimous FC. FC being a football club. Unanimous being the unanimous.
The first time.
Yeah, oh, okay. Unanimous means they unanimously agree with a lot of things that the government brings.
But before your next question, please don't lose track of it. But I agree with them 100%. I have myself, at my lectures, suggested to my students and complained that I am against this unanimity that we have a Supreme Court, be they 7 or 9, they are always in
added them.
Yes, they are always added them. What sort of jurisprudence is that? Don't they have minds of their own? Even if they will be added them, let each of them express himself or herself
variously.
It
shouldn't be a joint
dictates of the Constitution.
It shouldn't be a joint judgment.
The Chief Justice says so and so. I agree. I also agree.
You want us to hear why they agree? They should
sure.
So separate judgments, even if they
support. Sure. Separate opinions.
Okay.
Because there they don't give judgment. They deliver opinions.
Yeah. Okay.
They deliver opinions.
How can this mistrust be cured?
It cannot be cured for so long as we all agree. I've said this thing before, and I'll say it again on this occasion. When I was director of the law school, I used to participate in conferences that between the chief justices and the attorney generals. And that is how come I'm able to say that if you have a case against the government, you cannot win. You always lose, because the previous practice that I observed was that the attorney general will come and brief the chief justice, and then they chart a common cause, before they go to court. And in certain, instances, on certain occasions, and this happened during the NDC era, they will even invite, certain persons and make them anonymous and take them to court. So the real people who went to court were not the litigants. They were borrowed
explain
litigants.
This, I don't understand.
No. So, this culture, occurred during the NDC.
Which one, Rawlings NDC or Mills NDC?
No, Rawlings, and that resulted in page 28. You see, when page 28 was taken out of context. So
what is that?
Page 28, the Tommy Thompson, had been, Tommy Thompson and lawyer Kwabena Mensah Bonsu, had been committed, to stand trial before scandalizing the Supreme Court, and in the course of it, I think the Supreme Court, said that truth was not a defense, where,
in defamation,
so
or in contempt.
Yes, contempt of court. I drove Kwabena Mensah Bonsu to Nsawam prison after that, conviction. You see, and I learned, useful lesson from there, that it turned out that the person who had brought the application was non-existent. Okay. So they arranged somebody, who could suck up to what they were doing, and it's been going on.
So this audience you talk about between the AG and the Chief Justice
is not a healthy one at all.
Is this something that was happening during the Kufuor era when you were director of school?
No.
With
the Kufuor era, I can stake my neck out for Kufuor. During the Kufuor era, the Chief Justices were first the late Isaac Aban.
Then Theodora.
Then, after Aban, Kwame Redu. And then after Kwame Redu, Theodora Wood. And then, Akwa.
Yeah.
Akwa succeeded Redu, and then Georgina Wood succeeded Akwa, and Sophia Kufu, Georgina Wood, and then Niyeboa, Sophia Kufu, and then Gertrude Tokonu, and Niyeboa. Now, during Kufuor's tenure of office as president between 7 January 2001 until he exited honorably in 2008. 2008 was the election, 2009 November. Now, what he did was to respect the Constitution. I remember when Akwa died, and there had been an attempt to appoint an acting Chief Justice. I wrote that under the Constitution, we don't have an acting Chief Justice to be appointed formally. Under the Constitution, the most senior justice of the Supreme Court automatically takes over as acting. So it's the most senior of the justices of the Supreme Court. Okay. He respected my view.
So I just want to know this. So you said there's a meeting between AG and Chief Justice. I want to know which era you're talking about. Is it the Rawlings era or
the Rawlings era?
So it didn't happen since then, or you're not aware?
Okay.
No. Let me
if it is happening currently, I will not know.
Very well. This is Face to Face on City TV. My name is Umaru Sandavado. We are coming to you from the offices of the former director of the Ghana School of Law, who is having a conversation with us. Actually, we are at these chambers where we are learning a lot of the law and understanding a lot of nuances around the law. We've talked about the Supreme Court justice delivery. When we come back, we'll talk about corruption and the fight against it, plus the Godfrey Dame issue. Please stay. You're welcome back. This face-to-face on City TV. We're talking to, I've just discovered that his name is Samuel Kwaku Ansa-Asare. He's a lawyer, former director of the Ghana School of Law. So let's talk about the 1992 Constitution. Review it or leave it as is?
Leave it as it is.
Even though
leave it as it is.
It gives too much power to the president.
Leave
so many
it as
things
it
that
is.
people think, just amend it, do a national referendum, remove.
Leave it as
some
it
things.
is. 1992, the first practitioner was Jerry John Rawlings, isn't it?
Mm-hmm.
Even Rawlings, we didn't feel that there was a need to review it. Kufuor came, everything, went according to the dictates of the Constitution. Mills came, everything worked harmoniously in consonance with the provisions enshrined in the Constitution. Why now? It is because there have been, basic differences between the operators of this same document we are referring to as the 1992 Constitution. If the operator, if the human agent of the Republic who has to operate the Constitution does not respect the Constitution, it will give the misleading impression that it is the Constitution that is at fault and not the human agent who is operating the Constitution who is at fault. As far as I'm concerned, our current president does not respect the Constitution.
That's a serious statement to make.
Yes, and that is the problem. It is not the Constitution that is the problem. It is the chief executive of the state who is the problem. Let me give you an example. Mm-hmm. The Constitution, with the provision dealing with the executive, that is from Article 57, 57, 58, 69, name them. The Constitution has outlined the ministries and the number of ministers. Previous administrations exceeded their limit, but the current one, at one time, we had over 100 ministers and deputies.
111 plus.
Yes. I mean, what sort of constitutional business is that?
But so it's not a breach.
It's a gross violation. You see, now, if, for instance, the current president will compare himself, the previous president, he will realize that even though the previous, president attempted to exceed, they did it in a way that did not offend the, sensibilities of the ordinary Ghanaian. But now the culture is moye kurano, musu kurano, na meye no more. Musu kura, mumpe 80 minutes, and timid be 100, mumpe 100, timid be 111, that sort of thing.
He was a human rights lawyer, celebrated. Not he was, he is. I mean, we celebrate him for the repeal of the criminal libel law and so many other things. Why are you calling such a person, a lawyer who is being a foremost member of the bar, a disrespecter of the foremost document called law in Ghana?
I'm judging him from what he's doing now, not what he had done before. What he did before, he wasn't the president, so we did not know. Now that he's president, we are all living witnesses to what he's doing. I respect His Excellency Nana Addo for his human rights activism. I respect him for his erudition. I mean, you are an aspiring lawyer, so maybe it will never happen. But if you had you have studied law, let's say some 15 years or 20 years ago, and you met Nanado, in court, so erudite, he knew his law, he had mastery and control over the legal principles, and you will love him. That is one thing. So the Nanado I knew as a colleague, legal practitioner, It's different from the Nana Addo I know today as president of the republic.
What changed?
Power. Power corrupts. Absolute power corrupts absolutely. And that is what has happened. It has entered his head. It has entered his head. So we say.
But there are checks and balances.
He doesn't respect them. You see, we have if I'm the president, if I want to play my role as an executive, I'll go to the Constitution and look at the articles from 57 to 88. Mm-hmm. If I'm a member of the Council of State, if I want to do something, the Council of State, I'll go to 89, 90. If I want to do something, concerning the legislature, I'll go straight to Article 93 up to 108. If I want to, deal with the judiciary, I go straight.
So always refer to the Constitution. Defer to the Constitution always.
Sure.
He does that.
Because the checks and balances are contained and they can be found in the Constitution.
But the checks and balances would come from the judiciary, would come from the legislature, and to an extent the media. Don't you blame these three other organs which are not checking the executive?
He who pays the piper
calls a tune.
Sure, that's all. That's the commonsensical interpretation of what we are having today.
Except that in this instance, the legislature pays the executive. So why is the legislature, considering that the legislature currently even has a head who is from the opposition party? In fact, there are views that this is the best parliament we've ever had because
I agree. I won't say ever, but the best
because of the numbers and also the fact that the head is not a yes man to the president's party.
The last bit.
The yes man.
Yes, he's not a yes man, and I respect and I'll continue to respect Bagby for standing up.
So why, in the midst of all that, we are not seeing the checks on the executive or the CEO of the country?
Simple. The president appoints the ministers and they koto the president. So you go, before appointment, go to the president's house. I observed this, during Kufuor's term, because I used to, visit Kufuor in the company of Darocha. So I got to know, the happenings, in his kitchen cabinet in his house. See, ministers literally beg the president. Some people beg the presidents for political appointment. I will never beg for any appointments. And if I am invited, I once told former President Kufuor, if I was ever invited, to accept a ministerial position, I'll decline, because on my way for vetting, the appointment will be revoked. So I won't go.
Why?
Because I'm very principled, and no one, I wouldn't want anyone to tell me what I should do, if that doing it will be against my conscience, and therefore, I won't accept to go and do something that my conscience tells me is not right.
So let's talk about corruption and the fight against it. Corruption was one of the biggest challenges that were thrown at the Kufuor government. He lost power, or his party lost power in 2008. Mahama had corruption again on his table as well as one of the biggest issues that the NPP used against him. He lost office. All these presidents, and including Akufo-Addo now, are talking about the fight against corruption. Let's take Rawlings out. Let's use Kufuor, Mills Mahama as one, and Akufo-Addo as one. Who would you say is more committed to the fight against corruption, and who would you say is less committed to the fight against corruption?
I don't have the statistics, but watching the political terrain and the various differing approaches to the fight, against corruption, I would say that this is the worst, government we've ever had to combat corruption. I have said it before. I think I granted an interview to Joy FM, and I said, any government that will come and shout from the rooftop, I'm going to fight corruption. This thing will be the worst, government in terms of fighting corruption. That will be the most corrupt government.
And that's what you think the Akufo-Addo government is?
The worst ever, the most corrupt government we've ever had. At least I've witnessed Rawlings, Kufuor, Mills, John Mahama. If I have to, score them, award them marks, the last will be the current government. I mean, we are all witnesses to, the scandals, scandal after scandal after scandal. The latest is the dam. We don't even know where the dam is.
The Polugu Dam.
Yes, the Polugu Dam. We don't know, what has happened. But there's a dam. One district, one factory. There's one district, one factory. The monies, we want to build a cathedral, so we take, money. The cathedral, when they started, I was interviewed. I said, this cathedral will never finish, and Nana will leave office. And then the incoming government will come and use the same cathedral, to milk us, So governments are just, milking.
So the lowest ranking for you.
So the Nana's government will be the worst, followed by John Mahama's government, and then Rawlings. And so Mills will be first, Mills will be first, Kufuor second, Rawlings third, then Nana's government last. In terms of, grade 1 to 4.
Best and lowest.
Yes.
He created the Office of Special Prosecutor, Nana Addo Kwaku-Addo, whose job is simply to fight corruption, hiving powers off the AG and giving that to the office. Is that not something to be celebrated? He keeps celebrating that and says he's even retooled a lot of the anti-corruption agencies. Is that not something that should count a feather in his cap?
I could objectively judge the contribution of the office of the special prosecutor if we had a person like Martin Amidu, as the special prosecutor. But the person we have now is, one of the, the appointees, who might have been brought there for a purpose. So far,
you don't trust his independence?
I don't. So far, what I can say of the Office of the Special Prosecutor, it seems to me, was created purposely, to exonerate MPP, offenders.
Really?
Sure.
He was not an MPP
Sure.
member.
I mean, let me give you an example.
Mm-hmm.
Cecilia Abnadapa is accused of appropriating some $45 million or something there, or done at the Silken thing. Fine. The minister's house helps. The house helps,
stole the money.
Still millions, and they acquire houses and this thing. Then we are prosecuting the house helps. When the special prosecutor went after Cecilia Dapa, I told my students that it will come to nothing. It will come to nothing. That it was just for to create sensational headlines, and that ultimately a court will just set her free, and it has happened. So do you think
Why do you blame a special prosecutor for the setting free of somebody by a court? The special prosecutor himself has even had cause to blame the judges.
It's all part of the game, my son. It's all part of the game. It is part of the game.
It's a charade.
It is part of the game. I don't trust, what is going on. So from Attorney General, Special Prosecutor, back to Attorney General, then it goes to the court, then 7 justices will say, unanimous. It depends on who. If it is an MPP minister,
Clear.
they are acquitted, cleared. If it's an NDC person, persecution. So, as far as I'm concerned, we now have a culture, of a divide. MPP, NDC, and I tell you, one day, should NDC return to power, they will do the same thing. I don't trust them either.
So there's no hope?
No hope.
So the country is lost?
We should, if, for example, we have a third alternative that we can look up to, then I can, honestly stick my neck out.
You're a member of the MPP?
Sure. But that doesn't mean that I should condone the rot that is going on.
Will you not vote for the MPP candidate in the upcoming election?
Oh, my vote is my secret.
Okay, but would you, because there are third choices that have come up, Alan Chemantin is coming up, even though he's from the MPP stock. We have seen other people trying to run independent. Do you think independence is the future, or a third person is the future? Can they even govern? Maybe
a coalition.
A coalition government.
Sure.
That's something
for now, for the next maybe 3 decades, so that we put our house in order. So if, for instance, we have a very credible independent candidate that we can all, look up to for hope, then why not? Because you take the MPP, they are corrupt. You take the NDC, they are corrupt. So what do? And we are bogged down to these two parties. And therefore, they are playing football with our resources. So MPP government comes, they will clear, and loot. NDC, they will come and loot. The time has come.
Your verdict on the Akufo-Addo government is not a positive one.
What
do you think that would mean to his vice president's chances in the upcoming election?
I wish the vice president had listened to me many years ago. I wish.
To have done what?
I had suggested to him in private conversation to be his own self and veer away from Nana.
You can't do that. Unless you want to be Aka.
I did. If he had listened to me.
He should be an Aka.
What?
An Aka, a Caucasian Aka. You want him to veer away how?
Just, leave Nanado.
Resign as vice president?
He wasn't even a vice president then.
Oh, when he was running mate?
No. When he was mentioned, we met in Hawaii, and my advice to him was, please.
Wash your hands.
You have a bright future. Don't go anywhere near there. Be your own.
This was 2008 or 2000 and when?
Maybe 2000, I think October 2008. Either October 8th or 9th.
So you worry for his chances now because of where he's coming from or who he is with?
Yeah, but for me, and from where I sit and coming from, I watch the scene. Here we are. You are vice to a president whose regime is being overwhelmed and suffocated by scandals. That scandal, MUD, M-U-D, MUD, motor.
Unwoga.
So if MUD sticks, it is very difficult to clean off. You see, no matter what, some will stick. I believe that the NDC are only waiting maybe 2 months to the time to unleash, But for me, I don't have confidence in both.
Okay.
Period.
Very well. This is Face to Face. We are having a conversation with a former director of the Ghana School of Law, who is the founder of Mount Crest University. We're talking about a lot of matters law. When we come back, the Godfrey Dame issue is the last thing I want to ask him about. Please stay with us. You're welcome back. My guest is Kwaku Ansa-Asare, also known as Samuel when he goes to church. He's
Samuel Kwaku Ansa.
Let's talk about the Godfred-Dame issue. It's a big scandal inside a courtroom for an accused person to accuse the Attorney General of asking him to help him prosecute his co-accused person. Scandalous. Can Godfred-Dame come out of this unscathed? You are asking for him to be fired. On what basis?
I don't think he can come out. I don't think he can come out. He cannot come out, simply because he has misconducted himself. And I tried to explain yesterday in another, interview to a different audience, that in the first place, the process that they embarked upon is unknown to our jurisprudence. It's not part of our judicial process.
The plea bargain?
No. You see, here we are. There's an accused person who claims that he could be in a position to make reparation, provided the offense of causing financial loss to the state will be dropped. In return for compensation. You'll be ready. He was ready to return or refund the money. Now, under our system, there is nothing like plea bargaining. But there is what we call plea upon arraignment. And the difference between the two is that the plea bargaining is a procedure or process that is, applied in America, whereby the accused person, his counsel, the prosecutor, and the attorney general, can enter into some, give and take arrangements, and then the offense will be dropped in return for the reparation or compensation. Here in Ghana, and they can do it privately. Here in Ghana, if you are, being tried, everything must take place in the courtroom before the trial judge, in the presence of your lawyer, the prosecutor, and the personnel of the judicial service assigned roles to play in that court. That is not what happened.
But there's a plea bargaining act. 1079-2022 Act.
Yes.
Is that not what can be relied upon?
No, that is what I'm saying. You see, the genesis of plea bargaining, which culminated in Act 790.
So the origin of the law?
Yes, the origin can be, found in Section 239, subsection 2 of Act 30.
Okay. Criminal procedure.
The criminal procedure. Then the criminal code 29. Had a similar provision. And it has been judicially interpreted in the case of the Republic against Onyinijan and another, and explained by a justice of the Court of Appeal who was sitting as additional High Court judge, Mr. Justice Osinemisa. And he explained it. And he drew the attention of members of the legal profession to the existence of what is now enacted in the Plea Bargaining Act.
So the wrongs of Godfred-Dame based on your reading of the law are what? One, that it didn't happen in the courtroom.
One, that he was the Attorney General and he was not, counsel for the accused persons. And this suggestion that the accused person didn't have counsel is neither here nor there. It is not the constitutional, responsibility of the Attorney General to, convert himself into accused person's counsel. That's not what the Constitution says.
We're hearing the meeting happening in the house of a justice.
That makes it worse because, as I said, every plea bargaining within the Ghanaian context must take place under the full scrutiny of the court hearing the case. The Supreme Court Justice, his house is not a courtroom. The Supreme Court judge is not a trial judge. The environment there is different. The Supreme Court judge will not have personnel of the judicial service at his beck and call there. And what our law says is that it must, be done within, all the safeguards that the law allows. So if you take it outside the courtroom,
you don't trust that the president will remove him based on this?
Oh, I said yesterday that the president doesn't have the moral courage, nor the political courage to do that. So Ghanaians, must remove him.
How?
We are the people. If you look at the preamble to the Constitution, we the people. And if we say that the president should remove him, and he doesn't, we impeach the president for not upholding the tenets of the Constitution.
That's how far you think we should take this?
Yes.
It shouldn't be considered a mere allegation.
No, this is not a mere allegation. For once, let us stand up. Let us defend the Constitution.
And this is not personal against the AG?
No. That is my son. I call him my son. I respect him. As I said, I respect him. But that doesn't mean that if he finds himself in an infraction of the law, then we leave it at that. No.
Before we go, just a few things. You were director of the law school. Were you a Rawlings appointee or a Kufuor appointee? Were you appointed under Rawlings?
2002.
Oh, so you were appointed under Kufuor?
Yeah, but I acted in 92, 95, 97, 98.
Despite your relationship with Darocha?
Under Rawlings.
Despite your relationship with Darocha, Rawlings still gave you a job like that? Oh. Or it was not
no, it's a general legal counsel.
So it wasn't a president?
No.
The government had
even though it's one of the offices, that eventually, but it's the general legal counsel.
I see.
But the president, can interfere, by calling the chief justice.
What do you think of the raging debate on opening up the legal education, that we have one Ghana School of Law at Makola, it doesn't have physical space, allow faculties to, proceed with the bar? What do you think of that?
Well, let me blow my own on.
Yes.
Until I became director, there was only one law faculty, the University of Ghana. That's all. Now, when in 2003, I decided to establish the law faculty in Kumasi and Cape Coast, so the majority of members of the bar, were against it. But, I had the vision that one day we need lawyers.
So open it up.
Open it up. As far as I'm going, if we have 100 law faculties today, the best for it. I set the ball rolling, and in my, time, until I die, I want to see many, many more faculties, coming up to train. The nation needs lawyers. Yes.
Samuel Kwaku Ansa-Asare.
Yes,
former director, Ghana School of Law, founder of Mount Crest University. Thank you so much for joining us on Face to Face. I appreciate it. Thank you so much. And my name is Umar Rusanda. I want to thank you for watching Face to Face. We appreciate you watching us here.